Please be seated. Good morning, everyone. This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The records reflect that Mr. Holmes is present with his attorneys, Ms. Nelson, Ms. Higgs, Ms. Spengler, Ms. Brady, and Mr. King. And the people are represented by Mr. Orman, Ms. Pearson, and Ms. Stitch McGuire. We are outside the presence of the jury. The jury sent out a note. It's a request, and it reads as follows. The jury requests a TV and DVD player, and it appears to be signed by the foreperson. I have marked the note as jury question number 1 during phase 3 deliberations. I have a proposed response which reads as follows. Dear members of the jury, this is in response to your request for a TV and DVD player. Which exhibit or exhibits are you interested in viewing? Would you please give copies of the question and the proposed response to the parties? And I'll give you folks a chance to review the question and the proposed response, and then let me know when you're ready to proceed.
We have no objection, Your Honor.
Ms. Brady? No objection. Okay, that's how we'll proceed then. I'll send it back to, I'll sign it, send it back to them, and then when we get another answer, presumably we will get another note, we will contact you, okay? So don't go too far. All right, the court will be in recess. Thank you.
All rise.
Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with Ms. Nelson and Ms. Higgs, and the people are represented by Mr. Orman, Ms. Pearson, and Ms. Stitch McGuire. The jury has sent out a note which I have labeled as jury question number 2 during phase 3 deliberations. It's as follows. We wish to watch People's Exhibit 1000. People's Exhibit 1000 is a crime scene video. I have a proposed answer, but before I share the proposed response with you, let me hear the party's position. Do the people want to state a position with respect to this request, Mr. Orman?
Our position is you should follow the same procedure that you followed last time of giving them the equipment for an appropriate period of time to include the length of the video and time to start it and stop it.
Ms. Nelson or Ms. Higgs, your position?
Same position, Your Honor.
Okay, and that's what I think we should do. Let me just, for the record, read from People versus Jefferson again. I read from this case before, and I'll read from it again. This is a 2004 decision from the Court of Appeals, 2004 Westlaw 2769104. And I am aware of the fact that this is pending review before the Supreme Court, but I'm only relying on it for purposes of the law that is stated in here, the law that's summarized, because I think it does a good job of it. Generally, a jury is permitted to take into the jury room all exhibits received into evidence subject to the trial court's discretion to order otherwise. That's from Frasco versus People, or at least the Court of Appeals cited to Frasco versus People, a Colorado Supreme Court decision cited at 165 Pacific 3rd, 701. That's a case from 2007. The trial court has an obligation, however, to ensure that evidence is not so selected nor used in such a manner that there is a likelihood of being given undue weight or emphasis by the jury. That also comes from Frasco. This obligation is particularly pronounced with respect to jury access during deliberations to portions of trial testimony and to exhibits substituting for trial testimony. Thus, a trial court must oversee with caution the jury's use of exhibits of a testimonial nature, including video recorded interviews of witnesses. The trial court must exercise its discretion to permit, deny, or limit the jury's use of a testimonial exhibit by assessing, number one, whether the exhibit will aid the jury in its proper consideration of the case, and even if it would, number two, whether a party will nevertheless be unfairly prejudiced by the jury's use of the exhibit. The court cited to Frasco for that proposition. Ultimately, the court has an obligation to assure that juries are not permitted to use exhibits in a manner that is unfairly prejudicial to a party. That also comes from Frasco, F-R-A-S-C-O. So, number one, this is not a testimonial exhibit. This doesn't have any audio, and this is video of the crime scene in the theater. So this is not of a testimonial nature. Number two, there's no objection to me providing a TV and DVD with certain limitations. Number three, I find that the exhibit will aid the jury in its proper consideration of the case. That's based on my knowledge of this case and my knowledge of the fact that the jury is deliberating now in phase 3 of the sentencing hearing, and the fact that the jury has specifically requested permission to view this particular video. And finally, I find that no party will be unfairly prejudiced by the jury's use of this exhibit, given the limitations that the court is placing on it and the limiting instruction the court is providing. So, based on that, I find that it is appropriate to send back Exhibit P-TR-1000, actually not send that back because the jury has it, but send back a TV and DVD player so that the jury can view that exhibit, but with a limiting instruction, or a cautionary instruction, I should say. So here's my proposed response. Dear members of the jury, this is in response to your request for a TV and DVD player to view P-TR-1000. The request is granted. However, the court instructs you that you may not give this exhibit undue weight or emphasis. Consistent with this instruction, you may only play this exhibit or any portion of it one time. Because Exhibit P-TR-1000 is approximately 45 minutes long, you will only have the TV and DVD player for 50 minutes. Finally, you may not play any other exhibit without authorization from the court. If you need additional time, please let one of the bailiffs know. If you would please give copies of the question or the note and the proposed response to the parties, I would appreciate that. Thank you. And the record should reflect that Ms. Zagel is doing just that. Take a moment, please, to review both the note and my proposed response and let me know how you would like to proceed.
We agree, Your Honor.
All right. Anything from the defense? Take your time. And for the record, one time is in bold font to emphasize it.
Your Honor, I recognize that we said we agree with the people. We don't. I am changing our position. I'm going to object to the jurors being able to watch this particular video. I think it's of a particularly graphic nature. I think it unduly emphasizes, perhaps improperly, any victim impact testimony that they've just heard. And we would object under the 5th, 6th, 8th, and 14th Amendments of the United States Constitution, as well as Article 2, Sections 16, 20, 23, and 25 of the Colorado Constitution.
Any response, Mr. Orman?
It's in evidence, Your Honor. The jury wants to see it. You've outlined the factors that the court should consider. And all of those factors, I think, can only lead to the conclusion that the jury should be able to view this video.
I agree, and I don't understand the change of heart by the defense. I mean, initially the defense said he had no objection to having the court provide the jury the equipment necessary to view the exhibit, as long as the court provided the same type of cautionary instruction that it provided before. That's exactly what the court is doing. So I don't follow that. And given that the defense initially didn't have an objection It seems to me that they themselves don't feel particularly strongly about this, and I don't know what prejudice there will be. This was admitted into evidence. I stand by my ruling related the admissibility of the exhibit, and I have gone through the two-prong analysis in Frasco and DiBella, that's capital D, small e, capital B, small e, LLA. And of course, here we're not dealing with a testimonial video, which is when the court has said we should be particularly careful for the reasons that have been articulated in DiBella, Frasco, and Jefferson, and perhaps other cases. Here we're dealing with a non-testimonial exhibit that in fact has no audio whatsoever. It is an exhibit of the crime scene, and I understand that that may be prejudicial in terms of it being damaging to one party or the other, but it is not unfairly prejudicial or unduly prejudicial. To the extent that there is any prejudice, it is a result of the exhibit having probative value and having been admitted. And I continue to believe that the exhibit will aid the jury in its proper consideration of the case. There's no argument that it will not, and there's no basis for me to find that it will not. And I continue to believe that this will not be unfairly prejudicial to anyone, given the cautionary instruction that I'm giving the jury and giving the limits that I'm placing on the jury. I'm telling them they can only play it once. I'm telling them they can only have the TV and DVD for just about as long as the duration of the video. And I'm telling them that they cannot even play any portion of the video more than once. So they cannot replay even any portion of the video. We're going to time them. I'm going to have my bailiffs actually literally start a clock and time the equipment being in the jury room for exactly 50 minutes, and then I'm going to instruct them to retrieve the equipment after the 50 minutes have expired. That's exactly how we did it before when this issue came up, I think during the deliberations at the end of the trial, and we're going to do it exactly the same way again. So for all those reasons, I stand by my decision, and I'm going to sign the response and send it back to the jury. Since I have you here, there is a motion that has been filed by the Denver Post for expanded media coverage, and specifically related to still photographs of the hearing that I'm going to have after these proceedings are over in order to sentence the defendant on the counts that are not subject to the capital sentencing hearing, and in order to enter any sentences required by the jury's sentencing verdicts. So I'm going to issue an order labeling that, I think a C-224, and then I'm going to give you a chance to respond. I would like a response by today, if at all possible. Is that okay with the parties, Mr. Orman?
Your Honor, I think we're going to probably want to see what the victim's input is, and that may take more than a day to get that, with there being so many.
You want Monday?
Your Honor, thank you.
Is Monday okay for the defense?
We have until Tuesday, Your Honor.
That's fine. I'll give you till Tuesday. Okay. All right. The court will be in recess. Thank you.